This is Ready, Set, Renovate, a podcast delivering renovation inspiration and motivating you to put your home beautifying ideas into motion. The idea for this episode originated after episode 7. That episode was titled Cost Plus versus Fixed Cost. One of my guests on that show, Larry Myers, later recommended I speak with an expert in construction contracts. I took his advice, which led me to the law offices of Holder, Padgett, Littlejohn and Prickett. And today, we're joined by construction attorney Stokley Holder. We're taking a look at characteristics of a good contract, as well as construction law in general and how it might be changing over the next few years. We're fortunate to also be joined by one of Daniel Builder's finest, a man well acquainted with the components of a construction contract. That's Andy DeLeonardis. Let's get to it. Here we are at the law offices of Holder, Padgett, Littlejohn, and Prickett. I get that right?
That's right. Mouthful.
We're gracious. You were gracious enough to join us, Stokley, and we're grateful for that. Today, we wanted to talk about contracts a little bit. This idea came out of a previous episode where we were talking to a contractor who did a cost-plus approach and mentioned how important contracts were, and actually recommended that we get in touch with an attorney to have him on, and really grateful that you're joining us today.
Sure. Glad to be here.
Just jumping right in, tell us a little bit about what you do and how you got to this point.
Okay. Yeah, well, I'll try to keep it brief. Myself and 3 other partners formed this law firm a little over 6 years ago. I've been out of school for 17 years, going on 18. I'm from Greenville. My family has been in the construction industry all of my life. My father, his father, started Holder Electric Supply, and we served tours in their warehouse growing up in the summertime. And then my mother's father, he was an engineer and CEO of J. Serene, big engineering firm here years ago. And in college, I had an interest in it. Went to grad school, obviously law school, and didn't exactly know which direction I wanted to go, but I was fortunate enough to have some good guidance from a judge that I clerked with, who's still the senior judge here in Greenville. And then from there, was fortunate to cut my teeth with some excellent construction lawyers who are still good friends of mine and mentors. And just kind of like most folks in my industry, fortunate enough to work with some really good people around Greenville and upstate and throughout South Carolina, and been blessed to open my own firm and continue with the successes that we've been fortunate enough to have.
Sure. Well, it sounds like you having a family that's in the industry actually gives you kind of some context and a point of reference that dates further back than your law school days.
That's right. And they're in the wholesale supply business, and so with a lot of legal disputes, money seems to be at the root of it. And with their business being on the supply side, there's a lot of contract type monetary disputes at times, and it can be you can relate that to most every business and every industry. So from a younger age, you got to appreciate. I gained an appreciation of some legal aspects of business, and then specifically in the construction industry. So that was certainly helpful.
Do you see a recurring theme as to what triggers these disputes? Is there things that seem to be common among them that if they had just done things a little different on the front end, they could have completely avoided?
Right. Yeah, that's a good question. I think if I had to summarize that, obviously we deal with all kinds of different disputes, but as you might imagine, that as I said before, I mean, they center on typically some monetary obligations or lack thereof. And I think, for the most part, it boils down to communication and and on the front end, typically as it relates to contracts and the mutual understanding of the parties. Preferably from a lawyer's perspective, there's a written contract, but even with written contracts, there are all kinds of problems that arise. But I think it does boil down, no matter what the size of the project is, the nature of the project, whether it's residential, commercial, industrial, whether there's a written contract or not. It's paramount that there's an understanding between the parties. And even in a situation with like suppliers, where oftentimes there's not a formal contract, there's purchase orders and invoicing. And in those cases, certainly communication is just as important, but particularly for the general contractor owner relationship, it's most important.
Well, in the cases where there is a contract, do you advise that the contractor go through that contract word for word with whoever they're contracting with? Or, because a lot of times contracts can get obviously really big. What should be the expectation going into a relationship where there's, hundreds of thousands, sometimes millions of dollars at stake? What should be the expectation of understanding of those contracts?
Yeah, in an ideal world, somebody sits down with the parties and explains the terms of the contract. I don't think it's realistic, however, for a builder to try to more or less play lawyer. And I'm not saying that just to suggest it's got to be a lawyer that looks at it. But I think because, like you said, I mean, contracts, it's the lawyers that are responsible are getting more and more complex and longer. In my opinion, it serves the interest of both parties to have a provision in a contract just making clear that the parties each had their opportunity and right to seek independent counsel, and that they're attesting to having had that opportunity and are signing the contract with an understanding of that. Whether they go and then get that counsel is up to them. But by the way, the law reads, if you sign a contract, you will be deemed to have the knowledge and understanding of every term in that contract. So it's a risk that everybody takes, but in terms of going over it, it doesn't hurt to go over it in as much detail as you can, both sides. But honestly, there's so much in the way of legalese in those contracts now that you almost
block out a lot of time.
Yeah, you almost run the risk if you're a contractor trying to interpret some of that and you get it wrong.
Oh, yeah.
That could come back to bite you.
Sure.
But I think it does. It does. In my experience, it certainly would be helpful to have an opportunity and provide the owner or whether the general contractor, whomever is drafting the contract, allow the other party to have the opportunity to go seek counsel and to include that in the contract. So there's no question later as to whether you had that right and opportunity.
Well, we're also joined by Andy DeLeonardis, who's part of the Daniel Builders team, and part of his responsibility is going through contracts with clients. Do you typically find clients are zoning out when you're getting to that point?
There are some times when that happens, yes, because of, like you mentioned, the legalese, the complexity, I guess, of all the different terminologies and stuff like that. And many times they don't have an independent legal person to go over that with them, or maybe just the size of the contract doesn't really necessitate that. I'm not sure if you would agree with that or not, but if there's a correlation between the two. So yeah, there are some times where they're really in tune with that. We've actually had we've done projects for construction attorneys, which is always interesting when we kind of tell them they can explain it to us probably better than us. But there are some times where they kind of zone out and kind of really would like to just have us hit the high points, and they aren't too worried about all the details in there. And maybe that speaks to the amount of trust that you have with the person you're contracting with, but also, there's a lot of importance. There's a lot of value there that you don't want to skip over.
Yeah, I agree totally.
When you're referring back to a contract and like it's a case that's gone into court and you're going back to contracts, are there characteristics that you're seeing over and over where the contract is failing to address certain things that is causing the problems, the legal problems?
Well, I guess the easy answer to that is that, yeah, every case that's litigated, that's always going to be an issue. Yeah, if it was clear in a contract, it's probably
Not going to court.
Yeah, not going to court. But as far as the different issues, whether there's some trend, I don't know if that's what you're asking, but if that, it's hard to know. They're all so different. The ones that get to court, they vary so much. I would say, I suppose, in the residential context, what we see a lot of, particularly now in the industry with the volatility, uncertainty with the labor and material markets, is a prevalence of cost plus contracts for new construction, which we didn't see in the past. And quite frankly, I would advise clients in the past, if a contractor presents a cost plus contract for new construction for a new house, that's should be considered a red flag.
Interesting.
But now it's sort of flipped on its head. It's evolved in such
Because of the volatility that we're seeing in
absolutely,
the market.
and it provides a justification for builders to propose a cost plus contract. And what we see is a lot in the way of misunderstandings surrounding cost plus contracts, and the law can be harsh depending on what side you're on as it relates to the interpretation of those contracts. You know, some folks that may not have either taken the time to understand and appreciate it, or perhaps there's a lack of communication there, or a combination of both, but lack of communication between the builder and the owner. They don't appreciate the fact that that estimate that was provided to them is
It's not really
a
the
fixed
same.
price
Yeah.
amount.
Oh, yeah.
Right. But that's in their minds.
That's what they lock on.
That's
Yeah.
right. And then suddenly they get invoices that exceed that estimated amount. And they're just like, wait a second.
Yeah.
And that's where things can turn sideways.
What about, so we're fixed cost. That's our approach. I know there's various things we run into through the course of a project that require change orders and, going back and forth a little bit on price once we have a signed agreement. Do you find that there are certain issues in a fixed cost contract that tend to lead to problems as well?
Yeah, and I think you just touched on it. By and large, it's the change order process that we see a lot of disputes centered upon. And the law's a little, it's not as clear as maybe a lot of us would like for it to be in some situations, but it's trying to address the realities of situations, and that is, even in cases where there's a provision within the contract that makes clear there's got to be a written change order in place, even signed before the work begins, what often happens, and I'm sure you guys have seen it, is that you establish a course of conduct where things are happening so fast on the fly, and changes are being made by owners, and probably some owners more than others, that you establish, well, you don't follow perhaps the letter of the contract. But the law has carved out an exception for those situations that deals primarily with the course of conduct. But that's akin to saying, yeah, there's some standard of reasonableness that applies, and you're like, what's reasonable?
Right.
And that's what gets to court. But,
Sure.
Yeah, I mean,
Within change orders, I'm just wondering maybe if, clients kind of look at those things. It's a little bit of a dreaded term maybe sometimes when they see it in a contract. What are some good things that, a client could look for specifically around the wording or the process of how change orders are done by a contractor when they're, getting ready to sign some kind of an agreement?
well, I think it's important from an owner's perspective and contractor alike, but based on the nature of the disputes that we see, I think it's always important for there to be that provision that requires written consent prior to the work being undertaken. But, kind of backing up, what we advise clients about in those situations is the importance of diligence on the front end. There should be plans and some specifications, and change orders often arise when there's maybe some gaps in the details. And so to be able to take the time, and I'm not saying everybody has it, and I know oftentimes you get to the point where you're ready to sign a contract and there's some urgency with maybe financing and whatnot. But if you can take the time as an owner to understand the plans and the specs and trying to figure out where perhaps there needs to be more in the way of discussion or an understanding so that there's, you decrease the chance that there is the need for a change order.
So just everybody being on the same page, understanding the details, expectations.
Right. Yeah, I think that's important. I mean, as you guys know, and I can attest to, I built a house like 8 years ago, and those initial meetings where you spend the time, preferably with the design professional and the builder, whether it's design build or not, and you go over all those aspects, not just the plans, but the specs. And obviously with fixed price contracts, you understand the allowances, you do the diligence on determining who the vendors are and what the levels may be, say with countertops and the price points, so that you have a pretty good understanding going into it. That this may be where we splurge or not, and appreciate the monetary effect on that decision.
Sure.
Are you seeing a lot of warranty issues among builders getting into court? Like there's problems that arise after the contractor walks away and all payment is made, but then honoring the warranty, are you seeing issues arise frequently on that front?
Yeah, we do, and of course, construction defects, what we're talking about, and that there's so much litigation surrounding construction defects, and as you might imagine, and the markets that we've had of late, where it's so hard to come across good labor, there's usually it's a correlation with the spike in those claims. That once people, and unfortunately sometimes it's when there's a dip in the market and you finally have an opportunity to catch up and realize, all right, here's where I need to pursue, whether it's a general contractor against a sub or owner against the GC, a claim. And the difficulty surrounding the warranty process is always an issue. I mean, as much as us lawyers like to think that we can contract around it, or at least contract in a way to where it's specific and clear what the obligations are, and I'm talking in terms of representing a contractor. The reality is that the building codes are always going to be there, and if with the LLR, who does a pretty good job, the South Carolina Department of Labor Licensing and Regulation, they do a good job of sort of policing the construction industry, and they don't care what's in a contract. That's irrelevant to them in large part. If you, for instance, have a situation where you've tried to limit the warranty obligations to a certain time period, and yet beyond that time period is determined that there was a defect, a violation of a building code or residential construction standard, you go to the LLR as an owner, and as I said, they're not going to care about a contract, and they will do their investigation, which they do a very good and diligent job of handling, and they issue a report finding that there's a construction defect. It's hard to convince a judge that despite what the licensing entity of the state says in terms of this apparently clear construction defect, there's this warranty in place, and they've contracted that out. We've disclaimed that, and they don't. You can try, but it doesn't work. That being said, I mean, it's certainly wise to have those limitations and clear warranty provisions in the contract, and because there are certainly a lot of instances that arise where there's perhaps a workmanship issue that's not covered by a code, and I think you have a much stronger legal position to take if you can rely upon a warranty in those contexts.
What happens when it's not workmanship and it's more a material defect? Do you go after the manufacturers as well in this construction law that you practice?
Yeah, but it's you start then crossing some lines into product defect, and even though it's in the construction industry, when you start talking about that type of litigation, it becomes a challenge in terms of the time and cost, because oftentimes, based on the standards that apply in order to prevail on those types of claims, you have to get experts involved. Not to suggest you don't have to for a lot of the construction defect type claims, which you do, but that takes it to another level. I mean, that's almost getting into like class action type scenarios to make it worthwhile based on the cost and the effort that go into that, because generally speaking, you're going to be dealing with a pretty large company.
Right.
And they're going to fight, and they're going to have the resources to fight.
And you probably need more than just one example of one client having an issue with it.
Right.
I would think have to have numerous examples.
Exactly right. And those owners typically aren't going to want to foot the bill for that kind of litigation and the cost and time that goes into it.
As far as the contractors that you often you work with, are you doing tract homes, renovation contractors, custom homes, the whole gamut?
Yeah, we do it all. I mean, the reality, I suppose, is that with the tract home guys, the more high volume builders, I guess the law of averages, you're going to deal with more claims.
Sure.
With their work, not just because of the high volume, but it's no secret that with that comes more. I mean, with the high volume guys, their product is not like the big high end custom home builders, and when you
there's just so many more people involved, right?
Right.
So the likelihood, like you said, is greater.
Right, and you think about the challenges in the labor market, and those guys are paying their labor less in large part compared to the others, and with that comes risk and problems, and those guys getting paid what they're getting paid are more apt to maybe cut corners, and so there's more of the likelihood of claims that arise from those types of projects and with those builders. But their margins are such that I think they take that into account as far as cost of doing business. But there is, I think, certainly on average, more claims in the residential context with those high volume tract home type builders.
Kind of piggybacking off of that, what do you, I don't know how much crossover there would be between kind of the insurance world and your world, but obviously there's a lot of there's homeowners insurance, there's contractors have all different kinds of insurances. How much do you see that impacting contracts and also what you guys end up dealing with in lawsuits and litigations?
Right, that's a great question. So insurance in the construction context is unlike any other context of our lives. And you guys probably know this, but even a lot of builders are confused about what a general liability policy covers. Almost every owner is not aware of it. But when somebody says, a contractor comes to an owner and tells them that we're fully insured, it could be a little misleading whether they know that or not. But obviously when you're in litigation, or if there's a dispute that is substantial enough to where it's going to make sense for the contractor to consider paying a deductible and triggering their insurance policy. And almost in every case, when you're a claimant or an owner, you want insurance to be involved to the extent that they will have coverage, because that's as close to getting a check by way of judgment than anything else, because the judgment's worth the paper it's written on until you can collect on it. And with having an insurance carrier standing behind it, it's likely you'll collect. The problem is, and I can go on forever about this, I'll try to keep it simple. In a construction context, the only thing that those general liability, they call them comprehensive general liability policies, but the only thing they cover what we call resulting damage. And so to try to illustrate that is in the most simplistic way I can, consider a roof leak. So there's a lack of proper flashing, which results in damage to insulation, sheetrock, flooring. That in most cases, the general liability policy will only cover those damages that result from the improper work. So it will not cover the costs related to replacing or repairing the flashing or the work, say it's something inside of a wall. It won't cover the cost of getting to that defective construction. They will only cover the damages that result. So in my example, insulation, sheetrock, flooring. And that's so if you think about a lot of the defective construction cases that may arise, if it's not water related, you have to get pretty creative, or foundation related. Oftentimes you have to get creative in trying to establish that resulting damage to trigger defense, the duty to defend under those policies. And then there's a separate issue of coverage.
Sure. So builder's risk, I mean, just all those different other kinds of insurance that can be added on to bridge that gap.
There's not much that bridges it, unfortunately. And builder's risk, certainly in case of a situation where there's theft or a natural disaster,
Okay.
or if somebody gets injured on the job, but that doesn't cover that gap associated with defective construction and those damages that are outside of resulting damage. And homeowners insurance policies aren't going to cover that for a number of reasons. But so there's risk there, and that's what we advise owners on the front end all the time about those limitations that apply, and that's important when it comes to folks you contract with and the quality of work that they perform and how they stand behind that work and can financially, and whether they, a lot of folks are willing to do it, but financially it becomes a different story at times.
Speaking of workmanship and labor, are you seeing much in the way of illegal labor cases arising?
Well, I mean, we know everybody knows it's happening. But we don't see much in the way of claims specific to that. Obviously, as you might imagine, when that becomes issues because of some other problem, most of the times defective work. And so when you're a claimant, you're going to take kind of the kitchen sink approach. Not only is there these code violations, there's this lack of supervision and oversight. There are these unlicensed, unqualified, inexperienced, perhaps illegal immigrants performing labor, and it's kind of a add-on, so to speak. I'm unaware of a situation of late where, despite the prevalence of it, there's been specific claims through construction lawyers. Now, government entities may be different, but I haven't seen where there's been direct claims associated with it, because the reality is, I mean, there's a benefit to those guys no matter how you cut it and whatever kind of idealistic political position you take.
They're going to protect the benefit. Yeah.
Yeah. Man, there's benefits to it, no matter how you look at it.
Sure. Well, let's paint a scenario. Somebody's been truly burned by a contractor and they're looking at recourse. Give them kind of a step-by-step guide how they can get in touch with you, what they should be doing, what kind of information they should be gathering, documentation, preparing for a potential court battle.
Sure. Well, again, I'm not trying to create work for us because most of the guys, including us, that are in the business are busy. But I think it makes a lot of sense that as soon as you feel as if there's a problem and you getting burned, it comes in a lot of different ways, both sides.
Sure.
But if we're talking about a concern related to either construction defects or billing issues, I think it's wise to reach out to somebody that knows what they're talking about sooner than later. And unfortunately, there aren't many of us that handle this type of work. And they're guys that do a little bit of everything, and I admire them for doing it, but there are a lot of risks associated with it. I mean, this is all I do together with real estate litigation. It's hard to keep your tabs on the law and how much changes and how much there is to it. But I think it's important to talk to somebody that knows that is versed in the dispute process, and to do it sooner than later, because you might find out that there's not an issue, or that there's some alternative to using lawyers to resolve it. And that's my main objective. Whenever anybody ever comes to me, I always tell them, listen, my job is the way I see it, and not all lawyers do, is to limit problems, not create more, and to focus on the resolution. And a lot of times, most always, there's a path towards resolution that doesn't involve court. And that's
good.
There's always the legal side, but almost always just as important, if not more important, is the practical side. And when it comes to legal fees, time, effort, stress, that's got to be considered on the front end. I don't care what side you're on, defense, plaintiff, owner, contractor, or anybody in between. You got to appreciate all that to understand the best path forward.
Have you found that if you could just get the parties in a room together to talk through their differences, that there is resolution more often than not that way? Or because I would think if they're not even talking anymore, if they're not even communicating, if they're resigned to go to court, I mean, it's going to be in court.
Yeah. No, you're right. And I think the best evidence of that may not be in such an informal manner that you're describing, but it's, I think, a good indication of how beneficial that is now the requirement in our state that every civil dispute, including construction disputes, are mediated before they go to trial. And yeah, that took place about 20 years ago. And some of the old timers had their concerns about how effective that would be, but nobody nowadays disputes the effectiveness of mediation. Mm-hmm. And what we see a lot of times is the contracts, and we certainly advise folks to include a mediation provision in your contract, whether it's formal, informal mediation, that should take place before anybody can go to court. And the statistics speak to the success of it. I mean, we have annual CLEs, continuing legal education conferences each year, and they go over those statistics and the amount of the proofs in the pudding, the amount of cases that go to trial, and particularly jury trials in Greenville County alone for civil cases is less than 1%, and a lot less than 1%.
Wow.
And if you go back before mediation, it's a lot more than that. So whether it's construction dispute or any other civil dispute, without question, getting people to sit down, whether it's with a mediator or lawyers or not.
So a mediator doesn't necessarily have to be an attorney.
That's correct.
Okay.
Right. Most of them are in our context because there's just so few folks that have the understanding of the different issues that arise. And almost always when you're in a litigated case and you have to mediate before trial, it's a lawyer. But whether you do it pre-litigation, litigation, or pre-termination of a contract, without question, it's a benefit. And we always advise folks, if you have that opportunity, you need to do it.
Mm-hmm.
So do you see, do you have any advice for ways that written in a contract, people can kind of have a pre-established way to handle issues that arise before they get to any of the legal stuff or even mediation?
Sure. Oh, yeah. There are a number of things, and we see it often. You know, I guess from the outset, there should be a notice provision as it relates to how an owner or a contractor puts the other party on notice of an issue. And there are typically, you know, some contracts sort of turn that on its head and create more of a barrier to resolution, the way they draft those in terms of the burdens they place and sending it certified mail and all that. But I think at the root of it, it does serve that purpose. It allows for there to be a process before somebody can get to court. They have to satisfy these notice obligations. There is a statute. It's a notice and opportunity to cure statute. There's good intent by the legislature behind it to try to facilitate that type of resolution. It hadn't played out, I think, as well as they'd like. There's been a little more teeth to it with some of the law that's evolved over the last several years. But yeah, whether it's a matter of providing the notice, you know, including a notice procedure, but also, as I said before, that mediation process, we see that now and more in contracts. And the reality is, like I said, it's easy to sell if you have to. You shouldn't have to sell it, but it's easier to do it now because of the obligation, the legal requirement that everybody mediates before you litigate.
Right.
So might as well just include something like that in the contract.
One, and going back, obviously any transaction, there's an amount of trust involved. And these are big dollar amounts, sometimes huge dollar amounts that you guys are dealing with. So how does a client know that they can trust their contractor? You know, what kind of things do they look for red flags when you're talking contractually? Obviously, if there is no contract, that would be a big red flag. What other kinds of things can they look for to say, yeah, I'm not sure this is somebody I want to sign something with?
Right.
This might one day end up in a courtroom.
Right.
Yeah. Well, it's a good question. I mean,
that's where they just need to come and sit with you and go.
Yeah, there's so many different ways in which red flags, of course, come up in our cone-headed minds. But yeah, I guess the best example is the one I touched on before is prior to this day and age, cost plus contracts on new construction. but that's kind of evolved to where it's becoming more commonplace, at least with custom home builds, certainly. But there's so many different ways in which we talked a while back about the arbitration provisions and how sometimes that can be used more as a sword versus a shield in terms of facilitating some reasonable dispute resolution process. That can be a red flag. But yeah, I think it's a matter of sitting down and talking to somebody that knows the ins and outs of those various issues that can arise. And because my goal when I do contract negotiations is to try to find that level playing field, if you will. And it becomes pretty apparent to me when I go over a contract, whether the intentions of a party based on the way the contract has been drafted. A lot of times you'll see something that's so extreme in terms of how lopsided a contract is in favor of one party versus the other that, I mean, that's a pretty big red flag to me. And most of the time, not to suggest that folks shouldn't approach things with a proper business mindset. And that doesn't always mean they're doing something nefarious. But having the opportunity and taking that opportunity, despite a little bit of extra time and maybe a little bit of extra money, to appreciate the provisions and what you're about to sign and how it could affect you. I mean, that's, to me, is so extremely important. But I get it. There's a scale there. I mean, like you touched on, it doesn't make a lot of sense to spend money and time on certain contracts where the scope of work may be limited and the amounts are limited. But that's up to the parties and the facts.
Great conversation. Really thankful
It
for
can be boring.
But no, it's very needful, I guess is the best word. Sure. Obviously, when people say, attorneys are the topic of jokes until you really need a good one.
That's right.
and then suddenly you have another perspective on them. But grateful for the time that you gave to us this morning to talk a little bit about contracts. And I think it's going to be insightful for those listening and contemplating a major construction project. First of all, to know that, if it gets into some big money and you need a great attorney, I think Stokley could be that person. And obviously willing to just keep things very straightforward and simple enough for me to understand.
Yeah, no, I appreciate it. I appreciate the opportunity. And I mean, whether it's me or another lawyer, we're blessed in this area to have some very good construction lawyers. We all get along for the most part. And whether somebody comes to me or somebody else, they'll be well served no matter what around here. We're all fortunate to be where we are.
That's for sure. Yeah, it is a great place to be. There's a lot of opportunity right now.
Got it. Thank you, guys.
We're delighted you tuned in for today's episode of Ready, Set, Renovate, your guide design build resource. Are you ready for your home to undergo a transformation? We'd love to talk to you about it. Visit us at danielbuilders.com and tell us about the home renovation you envision. In the meantime, subscribe to Ready, Set, Renovate, and we'll keep the renovation inspiration coming.